petition by mistake they mark the pagination in certified copy, my lord, and the department not only.
If, tell them to accept it. You want it to be accepted.
Yes, my lord.
Have it accepted. Yes. Just a minute.
Item number one.
Just a minute. Has it been?
Maybe permit to mention one matter, minor.
Yes.
With regard to item number 96, minor. In this part, I am for the petitioner, minor. It's a change brief. I have accepted brief yesterday, minor. Kindly let this matter appear on to be mentioned because opposition has been filed, but reply has not been filed as yet, minor.
We don't know. When you accept a change brief, you accept all the responsibility.
Yes,
That
sir, but
cannot be a ground for adjournment. We are very sorry. We don't like such prayer. When you accept a
Time for filing the affidavit.
we'll see when it is taken up. We will not grant any adjournment just because a lawyer has changed. That's no ground. Please. Yes.
Item number one.
Time for the petition.
I am for the respondent.
Compliance of the order passed by the
Let's see where's the tribunal's order.
there is a last annexure, my lord.
Tribunal's order passed in OA. OA.
Oh, yeah.
Which is not under challenge. Which is
Page
not under
146.
challenge.
Page 146.
No, if they are complying, why should they challenge? Only if they are not complying, they have to challenge. Let's see. On 46, sir, we are asking you where is the order passed in the OA?
Give me 1 minute, my lord, because I'm constrained to. Page 149. Can you see page 149? This is the order.
Yes.
Kindly see page
So after this order, what have you done?
162. Kindly, your lordship. Page 162, your lordship. Kindly.
Yes, we have gone through. We are asking you after this order, what have you done?
They were continued.
They were continued
Yes.
till
Please, my lord. Twenty-four, 2024. 2024. And also after that, there was a gap. And again, they were appointed purely on the basis or on the contractual basis. And
So that means they have continued even after 24.
it's because of they were taken as a employee there, as a teacher there. They continued.
So which one has been discontinued and on which date? Who has been discontinued and on which date?
Petitioner number 3.
Yes, petition number 3 has been discontinued. On which date?
31/10/2017.
Two 2017. Just now you said they continued till 24.
Other than the third one, because in the meantime,
So after the tribunal's order, was this petition number 2 ever taken back?
1 and 2.
Was petition number 3 ever taken back?
No,
Why?
because she didn't join previously, and in the meantime, there was a process for appointment of permanent teacher, and that was done to UPSC.
Only one teacher.
Only one post of teacher.
On what date the appointment has been made?
Your Lordship, kindly see page 190. Your Lordship, kindly see page 190. Offer of appointment to the post of postgraduate teacher, Bengali. Level 8.
Sir, this is offer of appointment of July 24. Why she has not been allowed to, or he has not been allowed to join in 17, we are asking you.
After that, she didn't join even.
Where have you said that? Where is this statement that she refused to join after the tribunal's order?
Not refused. She didn't attend. So
Where is that assertion?
page 10 kind. Kindly come to page 3 only. Paragraph 3. Paragraph 3. Your petition states that the present writ petition is being filed challenging the order dated 15/5/2025 passed by the learned tribunal in contempt application, wherein the tribunal has directed the
Sir, we are asking you, where is your assertion that this petitioner number 3 did not join? We are not asking you to read your entire petition here in court.
that is not as person. There's a
Then how can you make a submission when it is not stated by your client?
join even.
How do you say that when there is no assertion? Either it is your client's case or it is not your client's case. How can you make out a case which is not there in the record?
That doesn't mean
What do you mean admittedly? Unless you make an assertion, where is the question of admission?
record.
So show us.
Pradhan, in paragraph 3, your Lordship, kindly on 1, 2, 3, 4, 5, 6. Has not rendered any service since her discontinuation done by the then authority on and from 31st 12 27, 2017. Your Lordship, kindly see this.
Yes, please, you tell us. He is not able to tell us anything.
The statement
Yes.
of my landed is absolutely incorrect. Because of this fact, my lord, since the order has not been implemented, I filed a contempt petition in the year of 2018.
Is your contempt petition on record?
Yes.
Let us see what you have said in your
Contempt
contempt
petition,
petition. He is saying that you have not joined after the tribunal order. What is your assertion in the contempt? Let us
I was
see.
ready to join, they did not.
Let us see. Let's see.
Contempt petition, I think, I do not know whether he has enclosed or not.
Have you enclosed the contempt application?
Did not enclose all the documents.
Doesn't know anything. Yesterday also we adjourned it.
Yes.
Today also you are unable to render any assistance to us. This is a wastage of time.
But my petition, pagination is not properly done.
Nothing
Some of
is
the
in order.
documents, they did not enclose, madam.
That is why we adjourned it yesterday, that you please come prepared. Today again you are not prepared. Unnecessarily wastage of time. List after 1 week.
Madam,
That's great.
But instead of 1 week after 12 August, any.
After 12th August. Any
This cannot be, because the
Then-
appointment has already been made.
we'll see. We
It is
don't.
practical, and that is on record.
All right, call the next case. Nothing is on record. You are not able to show anything. What do you mean on record?
On record.
Item number 2,
কবে ফিক্স করলেন? 14th August. Oh, 18.
Item number 2, I'm appearing on behalf of the petitioner, Your Lordship,
Yes.
led by my senior, Mr. Singh. Lordship, our servicing is not completed yet. Kindly make it not
Service is not required. If you want an adjournment, we'll adjourn it for the day. Not today.
My lord, in item number 2, my lord, my service is not completed.
Not required. Let it come. Let's see what is the issue.
My lord.
We have adjourned it not today.
My lord, please.
We
We have challenged the order of the tribunal dated 4/12/23 at page number 25.
Yes.
Beyond. Now, the tribunal has not gone into the merit of our case, and they have taken that similar matter was adjudicated by Hyderabad bench, and accordingly they dismissed that one, and this tribunal is bound by the decision of a coordinate bench. Therefore, they have not gone into the merit and adjudicated what we have given. Now, our case is distinguished from that case of the Hyderabad. Right. The judgment order itself of the tribunal, kindly see inner page number 8. And repeal para, my lord, what
Yes, on what ground you have assailed the letter of 7/10/2014? What is wrong with that
Yes, my lord.
letter?
Now, that is in page number 45.
Yes, we are there.
Now, what has happened? That this technical, they are holding the same grade. And 2005, when the new recruitment rule came, they changed the qualification of the direct recruit at higher BSc. But this BSc was earlier also there in 79 recruitment rule or 89 recruitment rule. And at that time, this was an alternative, BSc or etc. or matriculation and etc. And it is there. Now, here they are holding. Now, say this is the present pay scale has been given from 1st January of the 6th pay commission. So what is the present pay is giving? Now all we are holding and drawing the same pay from 1 on 6. But here the administration committed error. They have not given the higher pay, which was recommended by the 6th pay.
No,
So-
we are asking you what is wrong with
Yes,
this
ma'am.
letter of
Now, here,
7/10/2000.
number one, we are holding the same post. People who are below us, because the new recruitment in the seniority list, I am the in charge. They are holding under me, doing the same work. And all on a sudden, after 8 years, they are getting low pay. I am getting that. All on a sudden, they are given a higher pay, and I am not given. This is it is illogical, etc. And this
It is what illogical.
stipulation. No, this is stipulation
Yes.
itself is irrational, illegal, because it does not have any rational relation to what objective they want to do. And therefore it is totally this within a class they have made another class. So it is the violation of Article 14 and 16. This is the main thing. And the decided cases are there. I have mentioned 2 cases. Apex Court, they are continuously holding that people who are holding the same post under the government, the same
Substantially,
single post, doing the
substantially,
same work.
substantially, you are making a claim on the principle of equal pay for equal work. Now, when a distinction is sought to be made on the basis of educational qualification, which has a nexus with the job which they are discharging, they are
No job
lab technicians
no job
in the doctor, they are in the medical facility. If the employer wants a higher qualification, that is a violative of Article 14. Yes.
That higher educational qualification is not a prerogative for skill and efficiency.
So let us see the judgment which says educational qualification means nothing. Yes, let us see.
Apex Court judgment. I doubt to think it.
That's the only issue.
এই দুটো নে?
Given by the
অতুল শুক্লা case.
director. Yes.
Paragraph 8, my lord. That is
Just a minute. Let us see.
it has been quoted from the Constitution with judgment, and the expressions are emitted by Justice Honorable Iyer. So let us eye this issue from an egalitarian angle of Article 14,
Please, 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 please. Please,
28.
please. Now, which paragraph you are reading?
28 and then 30 also. 28 is the main. In our page number 90.
Yes, there is no reference to any educational qualification in this judgment.
Another case, my God. Bit of Punjab, I have got Indian Kanun, I can keep it.
Any judgment that educational qualification cannot be made the basis of differentiating. This is not based on educational
They
qualification.
have not been taken into the qualification can be. I am accepting. When they have given other charges, they are making a hierarchy. They made a separate group. Within the group, it cannot. Qualification is immediate. That is
There is no group. They are saying you have to possess this qualification for getting the higher salary.
my lord, that is applicable for the direct recruitment, and this direct recruitment comes only when, as per the, I will show you
This requirement has been introduced in 2005. For 5 years, you did not acquire this qualification.
No, I did not, because I am recruited in 83. I am holding the post for 31 years.
Therefore, they are not saying that you leave.
Yeah, my lord. Just a minute. My lord.
This judgment is not based on educational qualification. This is on the line of that judgment, Air India judgment. Air India versus Nargiz Mirza or something like that. They said that all the other steps, particular step. This distinction is not valid classification. Yes.
I have two more points. Just kindly come to page number 36.
Page number of the judgment.
Page number.
Page 36 of the petition.
This is the recruitment rule of 79. When I
You were appointed under this rule.
under this rule as a deputy technician, and here the recruitment rule says
Serial number 7.
first BSc with chemistry as one of the subject of training, including this laboratory work, etc., or first matriculation or equivalent examination physics chemistry subject with diploma in clinical laboratory. So I was higher secondary with diploma. So I was the alternative, that is equivalent qualification. I have been appointed from 83. Now,
BSc with chemistry.
that's a BSc was there also, but
Huh?
BSc qualification it was there also,
Yes.
and the alternative is matriculation with the diploma. So I have been entered post with alternative. That's all. That's the equivalent qualification, which has been treated
So you are a matriculate with diploma.
when it has been treated as equal. So last 31 years it is treated as equal. Today, all of a sudden, without any justification, it cannot be treated as equal. And the anomalous position, my lord, the people along with me who entered had BSc that time. They are getting the higher pay, though they are lower.
So the change now is at page 88. Please come to page 88.
There was a chart given.
Hmm?
There was a chart.
So the comparison is at page 88. 79 rules and 2005. This is 2005 rule.
This is wrongly typed, my lord. 3/8/2015. It would be 2005.
This is
This
coming.
is wrongly typed, my lord. It would be
2005, I am not declining it. I am not denying it.
So this page has the comparison we are asking you.
All right.
So this SRO 104 is of 1979.
I am 79. Two other are from 90 under this one.
Supposed to be note here. Yes, you pass.
Earlier this one. And this is the second.
Yes.
Because it's 89.
Pass matriculation or equivalent examination.
14E was 89.
what the tribunal has done.
Applicant number 1. Has not gone into the merit, my lord. They have not examined anything. They are telling that we are bound by that one, Hyderabad bench. That Hyderabad bench order. I got. Like oh, correct. Oh, already.
So you are matriculate with diploma in clinical laboratory.
We are there. And some other are there that they have not come here because from here it is 39 posts in all India. So they are distributed in different places in this India because unexpected they have got hospital. My lord, tribunal, they have quoted the Hyderabad bench judgment. Tribunal, they have given excerpt from the Hyderabad bench judgment.
Hyderabad bench.
Sub tribunal. Now 32 page, my lord, they have quoted what Hyderabad bench has found. Page number 32.
No, that is not relevant. We are not concerned. Which Supreme Court judgment has also been relied upon? Which judgment?
Inner page of 8. That means
Inner page 8.
fifth para.
No, that is Uttarakhand High Court.
Fifth para. Fifth line. The applicants have failed to establish that their duties, responsibilities, and functions are similar to those whom they are compared to themselves. Because they are trying to compare with the railway. What railway laboratory technician in the railway hospital. They have also failed to establish that the distinction between their skill and pay with those compared with the is irrational and that it is no basis, has no basis, or that is dictated verified either law or fact. Now, a point is only that we are the only one, and it will. That the government of India, there is no single post or single cadre where there are two scale.
Only relying on Hyderabad bench, the order has been passed.
Two things, my lord. My preliminary objection in respect of maintainability. Petitioner has the grievance in respect of service recruitment order of 2005. They have the grievance in respect of, but they did not challenge.
No, they don't have any grievance regarding 2005. They have a grievance when you have, based on the 2005 rule, in 2010, you have sought to create a distinction, and that also based on a 2005 rule. You didn't do anything for 5 years. In 2010, all of a sudden you said that now you are also required to be having the same qualification.
2014.
14, yes.
Thereafter,
2014.
They preferred representation.
7-10-2014. 17-10-2014. That they have challenged.
They have challenged one thing, my lord. Kindly see page 59. They have challenged Roman 2. 709.
Yes, their rejection of their representation.
Just a minute, I am giving one.
The representation.
Are they still in service?
No, sir. Kindly see page 109. Department requested for relaxation for one time, my lord. On
Page,
109. And the Ministry of Defense has rejected, my lord. They did not challenge, my lord. On the very next page, my lord, page 111, and the said order was communicated.
they are not asking for anything prior to 1/1/2006. They are not asking for anything prior to 1/1/2006. This letter that you have shown us, it is rejecting that prior to 1/1/2006, no benefit can be given. It is not talking about with effect from 1/1/2006. In their prayer, they have said with effect from 1/1/2006, probably the day on which the central pay revision was made effective. That must be the date. Did you file a reply before the tribunal?
Yes, my lord.
What is your stand? Let us see.
Page 83, my lord.
before the Hyderabad bench, was this decision challenged?
No, it means
17-10-24, 2014.
Hyderabad judgment has not been challenged as per my instruction.
No, before the Hyderabad bench, the applicants, did they assail this letter of 17-10-2014? What is your case?
Well, Hyderabad, I have got the
Huh?
on copy of the order of the Hyderabad bench, because I don't know. That is what they have did. But they wanted to try equality and equation between the railway. I have got my lord last one point. I'll submit.
This has not been challenged. In your reply, have you said anything whether this 17-10-14 was challenged by the?
Kindly see para 12, my lord, page 93. You should
What is that page 93?
93 para 12.
Yes. Yes.
So that is the picture. নতুন আছে 2005 এর। হুম। হুম।
My lord, may I be permitted to make one point? That kindly see that 17-10-14 order. That order of 14, 17-10, that is what is in now here.
We have seen it.
No, my lord, what is my point? The Competent Authority and Government of India has agreed to revise the pay scale of the laboratory technician working in a hospital reserved as under. Now the present pay is this, and this has been revised. That means that pay scale is not there. Whatever we are getting from that one, it has been decided. It does not exist. Now, on which pay scale will be given? It cannot be. They are to given this revised.
Can one line from a document be read to
My lord, and that is given in that DOP.
to ascertain the meaning?
My lord,
The entire document has to be read. You cannot rely on one line. Just see what it says after that.
I am giving that.
Please read what it says after that.
That is there. The pay scale will be fixed on. And then they are telling that is laboratory technician.
So that is the document.
of
The
this-
meaning
what is
of the
point?
document cannot be
What is the
gathered
point?
from one line. The meaning of the document has to be gathered from the entire document, not from one line.
This stipulation is itself illegal. That is illegal. It is
Your case is that distinction cannot be made. That
And my lord, DOPT, kindly see the page number 132. Just DOPT.
page
132,
134.
132, 132.
Hmm.
62. Similarly, there is written recommendation by pay commission, that is why all posts in a particular grade have been granted a higher replacement.
Suitability is not to be seen.
Everybody should be it. That is the thing. So that is my point.
No, but they have moved the authority for that. The authority has said, no, it cannot be done.
That you cannot make the distinction within the same group. That is, they are working in the same work. Till now, they have not revised the work for the higher education qualification work. I have got from RIT that no, for the who has been recruited to the BSc, they have not given any higher job specification, higher work or responsibility. So the same person working in the same post, discharging the same work responsibility, they cannot be individually differentiated and discriminated.
See, one of the judgments that you have relied upon, this judgment of 15(1) SCC is totally inapplicable to your case. That has no application to your case. That there was a birthmark because they have been appointed like this, they are being treated differently. Apex Court says there is no blue blood in service law, therefore that cannot be done. So that is not applicable. This case, you please see para 18. We are conscious of the fact that differential scale of base on the basis of educational qualification and nature of duties is permissible.
Provided
So this has been,
there is separate work. That is the
and we have mentioned earlier also. Have you come with that judgment of Air India versus Nargiz Mirza? That is the leading case. You should have come with that case. I don't know. It is an old case. Therein the law has been probably relied upon in all these cases. Must be.
like pay scale. There is no pay scale.
Thanks. Judgment is not a fact. This judgment, paragraph 18, can be considered. What we can have, not have them. That basically will be granted. However, if the basic qualification and the job requirements continue to be identical, favor initially wrote, then the court shall be reluctant to accept it. So what is the basic qualification? Basic qualification is some of the higher qualification. Metric. That's all. Yes.
My submission is, my lord, page 31, paragraph 5, my lord. That is my submission, my lord, in this case.
Paragraph 5.
Page 31 of the input note.
Paragraph 5. That's the tribunal's order.
Therefore, my applicant screen entire page 31 and 32 is my submission, my lord.
No, that is the
Total
tribunal's.
objection.
That is tribunal's order.
Order, my that is my submission.
So you are relying on the Hyderabad bench.
Hyderabad.
Yes, take down. We'll pass the order, please consider. ये draft वाला.
Item number 4.
Viraj. Can be done. That is a better way of doing it.
But the service is not yet completed. The service is not yet completed. Due to some personal difficulty.
Service is not required. If you want to not today, we will adjourn.
Waiting for a week's time for service.
Not required. Let your senior be here. We'll see. Not today.
Five.
Met with the Lordship, my lord. I'm for the petition. My lord, am I audible to your Lordship?
Yes.
My lord, here the petitioner, my lord, before your Lordship has approached before this honorable court, my lord, being aggrieved by a refusal of interim order by the Honorable Tribunal. My lord, here, my lord, what happened, my lord, the writ petitioner, original applicant, my lord, as such, appeared in this examination of, my lord, for recruitment in the post of assistant loco pilot. And this examination, my lord, contained, my lord, 3 parts. So one, my lord, computer-based test 1, 2 is computer-based test 2, and the another is computer-based aptitude test. So, my lord, in computer-based test 1, my lord, I was declared to be successful. In, my lord, computer-based test 2, when I was called upon, I sat for the examination. So there were 75 questions, my lord, that was given in computer-based test 2. So in 75 questions, my lord, I answered correctly some of the questions. And, my lord, the cutoff for qualifying marks was, my lord, this percentage of 45%, my lord, which would be, my lord, 26.5. So among in 75%, I'll have to obtain minimum 26.5%. So, my lord, what I did, my lord, they published the answer key. So the answer key revealed that I obtained more than 26.5%. So accordingly, my lord, I was said to be qualified. Now, my lord, they came up with the decision that there were 4 questions which were wrong, or they did not say wrong or incorrect. They said that 4 questions were one was out of syllabus and the other 3 they did not explain. However, 4 questions they deleted, my lord. So when they deleted 4 questions, I basically, my lord, performed in the examination. I sat for the, I answered rightly 2 of those 4 questions. So Lord, you can mark that. So now these 4 questions are deleted. So when these 4 questions are deleted, then, my lord, my mark came down to 24 point odd. But surprisingly, my lord, they did not decrease the cutoff mark. They did, subject to correction, they did not do the simple arithmetic, my lord, that 75%, 75 numbers percentage, when it takes up to 26.5, then the question comes down to 71. The percentage of 35% would also come down, my lord, take the cutoff percentage low, I'm sorry, ma'am.
All right, no problem.
Oh, I'm sorry. Yes, ma'am. So, so when the number of the questions also decreases, so the cutoff part, then the mark will be counted not on 75 but on 71. So that
What is the effect of such an omission?
My lord,
What is the prejudice arising from such an omission?
My lord, the prejudice that my eyes, though I answered correctly the 2 of those 4 questions, my lord, my marks, my lord, come down to 24 point something, which is below the cutoff marks. Kindly appreciate, my lord, here. Yeah, I'm sorry.
So not lowering the marks of the on which the assessment is being made is not causing any prejudice because it remains the same for everyone.
No, my, I subject to correction. No, why I tell your lordship, my lord, say the another incumbent who sits for the examination do not answer any of those 4 questions.
Yes.
Do not answer. So
Still they will not get marks for that.
Yes, my lord, I tell your lordship, since
You
I
will also
rightly
not
answered.
get, they will also not get.
No, my lord, I tell your lordship, I rightly answered 2 of those 4 questions. Accordingly, I
That is
got
your
marks.
claim. That is your claim. They say that those questions have been omitted.
Now the questions,
Regarding
answers,
omission of
everything
a
is omitted.
question, regarding omission of a question and grounds to challenge the same, let us see what is the law.
My lord, can you see here? I tell your lordship. Now this situation, my lord, has also the simple
Ultimately,
arithmetic.
we
my lord,
have to
subject
see that you make out a strong prima facie case.
yes or not. Yes. Grateful. my
Or we are asking you,
Yes.
what is the law? Let us see
lord.
whether
lord,
deletion of a
yes.
particular question from the recruitment process, which
My lord.
applies uniformly to all, can be brought in question.
My lord, kindly sees, my lord, they have got one provision for that in the railways itself.
Whatever it is, even if they don't have.
Now
What prevents them from doing this? A recruitment body.
I do not say that they can't do it. But all I'm saying,
Yes.
my lord, how how they are, my lord, thereafter assessing the things. So, my lord, let us say, my
Therefore,
lord,
we said, see, there are 2 aspects of your submission. One is why they have deleted the questions. They have found it to be for whatever reasons that it was incorrectly incorporated. They have deleted it, applies uniformly. The next thing is that the marks on which the assessment is being made has not been correspondingly reduced.
correct. This is my submission before.
So the second, so therefore, what is the prejudice we are asking you?
So, my lord, what happens now? What happened? The prejudice, my lord, I'm facing. My lord, since if I just only take your lordship 1 point of the recruitment notice, and then my lord kindly sees that 1 point, only 1 point of the recruitment.
Plus the examination was on 15/7. What can be done now?
No. Here is the yes, my lord. I knew that, my lord. This would be. Luckily, we have just got to, my lord, get to know that they are because of these technical difficulties, they had deferred the examination for CBDT. My learned friend, my lord, who is before your lordship will hand up your lordship the recent notice of that. So that CBDT examination is not yet held. So on this score also, I was also having my.
Where is it? Where is that? Show us.
I'll just ask my learned friend, Miss. To hand up your lordship, my lord, the recent notice of this that deferring the CBDT examination.
Lordship, at page 109 of petition.
109.
Your lordship.
Is it in the petition? Yes, it is in the petition, sir. Vicky? It is in the petition.
So there is nothing right now. What is the urgency? They are saying the date and time will be informed.
Yes. Now, my lord, since it is refused, now what problem I am facing? Unless, my lord, this issue is decided by the tribunal. My lord, if your lordship, even if your lordship, my lord, pursuant to this 109, if your lordship directs the tribunal to take care of my case,
Is the exchange of pleadings complete?
My
not,
lord,
they did not use it yet.
They
did
have
not
not
use
filed
it.
a reply yet. Opposition.
They did not use yet.
My lord,
Yes.
It has just been taken up.
no, tribunal.
So if it could be,
How
my lord,
much time will take for filing the opposition?
My lord, 15 days is enough.
Why 15 days?
We have to take instruction, my lord.
What instruction? It is since
My lord,
14th.
My lord, my learned
The
friend
order is of 14th.
My
What
lord,
is the date today?
My lord, 1 point I have to mention, my lord.
We are not on the points.
My lord.
14th was the order.
My lord.
You need a further 15 days. Already it is what, more than 10 days. How much time? This is a matter of urgency. You take all the time, then
Kindly make it 10 days, my lord.
My lord, if your lordship, I'm so grateful your lordship has, my lord, directed that, because that would be, because I want this matter to be heard on
10 days
merits.
will be sufficient, my lordship. 10 days will be sufficient for us.
date has been fixed. No date will be fixed, I think. Probably whenever they fix a date, they will give at least 15 days time.
My lord, lordship, can you see the impugned order once?
Yes. Oh, 1 minute.
I'll be requesting, my lord, kindly, because I have just got a breathing space. So that because of this, my lord, 1st of September will make my claim infractures, because I was just, I'm so grateful, your lordship, that I really want this matter to be adjudged on merit. Absolutely. And if the tribunal would have, my lord, dismissed my claim now, I would have been the happiest person to come to your lordship. But now, my lord, I have got a very prima facie good case, my lord. Only one page I was referring to. Since your lordship it is following, I'm so grateful for this.
Where's the advertisement?
Yes, yes, yes. I'm grateful. But if I request your lordship, my lord, to see page number 34 of my writ petition, my lord. 20th January 2024. 34. The relevant page, if I take your lordship, one page, that would be 44. The relevant page.
So this is all over the place. It's not confined to this zone or division.
Yes. My lord, page number 44 once is, my lord, once.
Yes.
Page number 44, my lord, 12.2, lordship, you see, it is written as second
I have
second
legible
stage.
copy, Your Lordship, of page 44.
What is that?
Legible copy of page 44.
No, it is all right. It is legible. Don't worry.
So 12.2, my lord, second stage CBT. Has your lordship got that?
Oh, RRB wise. It will be done RRB wise.
RRB wise, yes. Now, my lord, 12.2 second stage CBT2. Has your lordship got that?
Yes, yes.
Yes, I'm sorry. So, my lord, kindly, my lord, comes down to the bottom of this page, my lord, with Roman 8. Sorry, the Roman 8 up behind, under that, capital B.
Should be asking the date instruction. Yeah, by what time? You can request the date, request the time. Okay. Date is there. Published within. What is the expectation? When do you expect the date to be declared?
We have no instruction, your lordship, yet,
Can you ask someone and come back to us?
my lord,
So that accordingly we can give some time so that
my lord, my lord.
So grateful.
maybe you are contemplating that it will take some time. Then
So
we
grateful.
direct accordingly. So we are not recording any order. Come back tomorrow.
So
Find
grateful.
out what is the position.
Kindly fix it on Monday, my lord.
Monday.
Monday.
Let them come back on Monday. By Monday, nothing will happen.
As your lordship.
The learned advocate representing the respondent.
I,
Item number 6.
This matter, I am appearing for the petitioner. On the last occasion, your lordship was pleased to direct me to file a supplementary affidavit in respect of a report filed by the SP. And it is a change brief. I received the brief yesterday. I require a day's time. Only a day's time to file the affidavit. I have gone through the papers.
They wanted to,
This, you will file it tomorrow.
Tomorrow.
So give him a copy.
Yes. Day after tomorrow. Day after tomorrow, kindly.
Give him a copy tomorrow.
All right. Yes.
A supplementary affidavit is to be filed.
Item number 7.
My lord, I am for the petitioner, my lord. My lord, the last occasion, my lord. My lord, I am for the petitioner, my lord. The last occasion, direction was given that, my lord, filing an affidavit in opposition. But my lord, till now there is no update, my lord. Already, my lord, last occasion it was extended, my lord.
Since May, it is being adjourned. By way of last indulgence.
Item number 8.
That also.
What state unit? But make it not today, your lordship.
Not today.
Nine.
Let 9 I accept.
Both sides are there.
They are expecting a judgment from your lordship today. Is that compassionate appointment matter? Where my mother applied. What will it her application never processed.
And during the pendency of our application, my father expired in 93. Immediately thereafter,
2nd October 1992.
92. Immediately thereafter, my mother applied. The last order, kindly see.
Yes, we have gone through. We have decided this issue already. Mr. Mukherjee, you are appearing in that case, where the elder brother had been murdered.
No, it is not that. What a tiny thing. Death took place in 1992. Mother applied when the application was processed. But the mother withdrawn her application.
Withdrawn her application.
That is highly valid. But mother withdraw her own application in favor of the son.
In favor of this, sir.
Whether that application considered because
you have considered, you have processed, you have
So
interviewed.
therefore, we are seeing the very, very similar facts. We have recently decided. One, the elder brother had submitted his application. He was murdered. The matter had remained pending for quite some time. The younger brother made an application. They said too late. We said now you can't do it because it is for the benefit of the family. We have decided recently. I think maybe a week back or 10 days back.
In this case, my application was processed.
We have recorded in the last order.
Yes.
We have recorded everything in the last order. It is clear.
After proceeding with
One application remains pending.
Hmm.
During subsistence of that application, it is changed.
Absolutely.
Therefore, whether it can be held belated or not, that is the issue. Because the rule in EMP 651 or whatever it is, 261, it says that where no application is made.
And not only that, if your lordship kindly takes up page 38 of the affidavit they have filed, the state has filed. Page 38. This is a letter
For maintaining consistency, we want to see that judgment.
May I get the name of the petitioner?
We are also looking at him, hoping that he will tell us. We can't remember the names.
Okay.
Every day.
May I know the date even?
most probably last week.
Perhaps last week or 10 days back, within last 10 days.
Actually, after
The judgment has been uploaded.
Yes.
the 4 reasons have been completing the application. The candidate do not attend the eligible of government service within the stipulated period of 2 years.
Delay. He must attain majority. So the same issue was arising there. He was 15 years old at the time of death. 15 years, 3 months or 4 days, something like.
It was really, there was no family members of the nature. They are all the nature. Right.
In that case, we had considered 26 EMP. We have considered 26 EMP, the timeline specified in 10A and 10.8AA, both. Yes.
Yes, but 26 MP is annexed to this petition, page 63.
So we are saying that's why we are saying we have considered this. So that is a keyword with which you can find it. That's why we are saying. With that keyword, you can find the judgment. Let's see whether it will apply. Let us see. We don't know. You may be in a position to distinguish. We don't know. We'll see.
May I come back tomorrow or Monday?
Let just have a look. Come back on Monday if you can find. Come back on Monday will be better. Tomorrow is too soon. As jointly prayed, list on. I can recollect the learned counsel who was appearing. I don't know his name.
Oh, जा, ताला रे. तो सब गया.
Item number 10.
Just now I am receiving this copy of opposition.
Opposition.
Just now.
Give the opposition. An opposition is filed today.
Who is there? Even okay. The একই matter, identical matter.
appearance.
Chart 10 and 9 chart.
Appearance টা দিন।
And more records.
11.
So this is also the identical matters as item number 10.
হ্যাঁ সোনাল সিনহার সাথে আছি কি নট টুডে হবে তো আজকে
অপোজিশন কি ফাইল করছো?
পড়বে আমার কাছে আজকে নেই সেই জন্য
আচ্ছা আমি বলে দিচ্ছি আচ্ছা this is also identical matters as item number 10 but they don't file their
Your Lordship,
opposition.
for the state, Your Lordship, due to some personal difficulty, Miss Sinha is not here.
Analogous matters. Issue is the same.
Then let it come. Separate opposition is required.
Not required.
This
Appearance 10 and 11 and 11.
আর 11 লিখলেন কেন? 10 তো আলাদা।
Me?
Item 12.
But may I beseech your lordships only to today? I am not ready. We can leave. But I am only filing the affidavit in opposition. They have also used a reply. My lord kindly puts that on record and fixes any date subject to your lordship's convenience. Any date subject to your lordship's convenience.
Not affidavit in opposition had already been exchanged. They admitted all the facts which is in the writ petition. Meritable. And therefore, it will take your lordship only 1.5 minutes time.
That's all.
That's all. Your lordship will take. I know.
So tomorrow at 4:28.
Yes. Yes.
But he would be signing another resolution tomorrow for 3:30, so 4:28.
Yes, tomorrow is also 3:30. So the opposition to Jama.
Where's the reply? Opposition and
March of life.
Under instruction, I am submitting my lord. Mr. Vikas Ranjan is appearing for the petitioner. He is already, parliament session is going on. I am praying some adjournment.
how much?
2 weeks at least, my
Let it come after 3 weeks. And is involved. She is a counsel for the
14.
Is the petitioner there? Then not today.
15. 16. 17.
Yeah, of the petition. File affidavit. The petitioner has approached this honorable court, my lord. Order passed by the learned tribunal, state administration. Time the claim of the my lord interest on delayed payment of gratuity. The order which has been passed by the case of the petitioner. My lord, your lordship, after my lord completion of 40 years, 9 months service, she has retired, my lord, from service on 30th September 2020.
Yes. In COVID time, the interest was not frozen. If the money was with you, you must have been earning interest. That's all right, but why they should be deprived? And how you can unjustly enrich yourself from this? Gratuity lies in current account. Therefore, it must be earning some interest. Huh? No, but gratuity till date of payment, how you can deprive him? You cannot. Whatever is the statutory interest, he is entitled to that.
As well as my lord, area pension was withheld for more than 2 years. After retirement, she has not got. Immediately.
Your relief in the OA, what is your relief? Show your prayer in the OA. What is your prayer?
Your lordship.
Oh, pension, gratuity, everything. File opposition. Yes.
There is delayed payment of area.
Eighteen, 19, 20, 21, 22, 23, 24, 25, 25. Respondent. No, call the next case. Call the next. 26, 27, 28, 29, 30, Other side is appearing.
Learned AG is leading the state in this matter, my lord.
Then will not take it up today.
But if your lordship permits me to place the prima facie case so that your lordship can express some doubts in my merit of the case, I can do some homework on that, my lord.
Let us see. Let us see how whether you can claim such benefit prior to 23. That is the issue.
Like to see the office memorandum of 2019, my lord.
Even 19 was not applicable in 2010.
2019, my lord, the 103rd amendment came, my lord. After that amendment, my lord, 2019 notification was published by the state government, my lord.
No, but your process is of 2010.
No, my lord. 19 subject to correction, my lord.
19.
After the 103rd amendment, my lord, constitutional amendment.
Oh. What is the date of advertisement?
The advertisement date is, my lord, my lord, 2019 was, my lord, the opening date, and my closing date was, my lord, 21st of that month only, 21/9/2019, my lord.
Date of advertisement.
The date of advertisement, my lord, 12/9/2019, my lord.
So you are qualified at any stage?
No, my lord. Only one stage selection process was there, my lord. Just interview and then.
Interview based. So you appeared in the interview. What was the date of the interview?
Interview was held, my lord, on 17 February 2020, my lord. Page 52, my lord, of your lordship's brief.
You didn't challenge the advertisement?
Yes, my lord. Advertisement is challenged before your lordship's, my lord.
No. Prior to interview, you did not challenge.
My lord, I raised protest, my lord, even before applying for the filling up the application for the post, my lord. And before in participating in interview, my lord, I also wrote to them, my lord, saying that I am participating without prejudice to my rights and contention.
Where is that?
That your lordship will be pleased to find, my lord.
Page 41.
My lord, subject to correction, my lord, page 53, my lord. My lord, since it is in vernacular, my lord, I have to the translation.
These documents, you will have to get it translated.
My lord, I'll just read the subject, my lord, and then I will translate it, my lord. EWS চাকরি প্রার্থী হওয়া সত্ত্বেও প্রতিবাদ সাপেক্ষ ইউআর প্রার্থী হিসেবে গ্রন্থাগারিক পদে ইন্টারভিউ দেওয়ার আবেদনপত্র. That means, my lord, despite being an EWS, I am participating as an UR candidate with protest, my lord.
No, give a translated copy.
I shall.
So many documents you are relying upon, it is written in Bangla. One of us cannot understand.
I bow down, my lord. I bow.
Give us a copy. Then you will require some time. How much time you will take for getting this document?
I don't have anything else. Today I will sit down, my lord. Your lordship skips it. Tomorrow I'll come back with all the translated copies in English.
It is submitted by learned advocate for
Thirty-one, 32, 33.
Petitioner Lordship, Mr. Siddhartha Banerjee is appearing in this matter, Lordship. I'm praying for a short.
not today.
34, 35, 35.
My lord, learned advocate Udayanarayan Betal is appearing for the petitioner. My lord, due to his personal difficulties, he has not come to the court. My lord, praying for only not today, my lord.
36, 37.
State, my lord. My learned friend is my senior, my lord. He is appearing on behalf of the state. State.
Oh, next.
38, 39.
39, my lord, I am for the petitioner, my lord. In this matter, my lord, the pleadings are completed, my lord. Kindly fix a date for hearing, my lord.
Tomorrow we'll do it. Not today.
40, 41, 42. না বলবে আমি তো ওইদিকে এবার অ্যাডমিশন 2 থেকে আমি ডাকবো 141 থেকে 141 142, 143, 144, 145, 146, 147, 148, 149, 150, 151, 152, 153, 154, 155, 156, 157, 158, 159, 160, 161, 162, 163, 164, 165, 166, 67, 68, 69, 170, 71, 72, 73, 174, 175, 176, 177, 178, 179, 180, 181, 182, 183, 184, 185, 186, 187, 188, 189, 190, 191.
191, my lord. Sorry. No, for the petition. Lord, I am suffering a punishment of compulsory retirement. My lord, may it be upgraded. My lord, it has not been taken up for as a motion till date.
Is somebody already appearing for the other side?
First day when it was called on, none appeared. Direction was given to me to inform them again. My lord, I informed.
Then today how he can maybe
Saying that today, my lord, it can be, my lord, so that it can be upgraded.
tomorrow it will come. All these matters will come tomorrow. This call the next.
Some upgradation so that it can
Call the next. This is not a mentioning time. Yes.
193, 194, 195, 196, 197.
Finish.
Original side, item number 1.
You have something to add?
No, my lord, I think I had just mentioned.
All right, take down. Sorry, we thought that.
I apologize. if
No,
I
no, no,
did
no,
not
no. We thought that you want to add something. All right.
Great.